Hi viewers, I am Suchitra Kalyan Mohanty, Assistant Editor in the New Indian Express newspaper in New Delhi. Let us today delve into the judgment delivered by the Supreme Court. It's a landmark judgment on April 8 regarding the Tamil Nadu government versus the Tamil Nadu governor of withholding of bills by the Tamil Nadu governor. So let us delve into that particular judgment of Supreme Court. Supreme Court sets 3-month deadline for the president for deciding bills. Absolutely, this is real crystal clear and landmark judgment by the Supreme Court, which has been delivered on April 8, and it has said that the president should decide on the bills reserved for consideration forwarded by the state governors within a period of 3 months from the date on which such reference is received. Well, this landmark judgment seemed to be a very good judgment by lawyers and top experts. The Apex Court said that the recent landmark verdict, which was uploaded on Friday late night through its 415-page verdict in the website in the case of Tamil Nadu state government's appeal against the governor Dr. Ravi for sitting over several bills passed by the state legislature. The Supreme Court has said that we deem it appropriate to adopt the timeline prescribed by the Ministry of Home Affairs and prescribe that the provision is required to take a decision on the bills reserved by the consideration of the governors within a period of 3 months from the date on which such reference is received. This is a 2 judgments headed by Justice J.B. Pardiwala and Justice R. Mahadevan. It is seemed to be a landmark judgment by the Supreme Court. The top court also in the verdict clarified that in case of any delay, an appropriate reason should be provided to the state government. I quote, "In case of any delay beyond this period, appropriate reasons would have to be recorded and conveyed in the concerned state," the Supreme Court said in the ruling. Unquote. The court also widening the ambit and the scope of the state government said in case a situation arises where the governor reserves a bill for the consideration of the president and the president in him withholds the assent, the state government could take action in court and assert this judgment or order of the state governor. The court also criticized the Tamil Nadu governor Dr. Ravi for violating constitutional provisions by delaying actions on bills passed by the state assembly. It said that either withholding of assent or reservation of the bill for the consideration of the president upon the aid and advice of the state council of ministers. The governor is expected to take such an action forthwith, subject to a maximum period of 1 month. Well, it is seemed to be a landmark judgment, absolutely. The court said that withholding of assent or reservation of bills for the consideration of president after their due reconsideration by the state legislatures is being contravention of the article under 200. The Supreme Court has clarified in the ruling on April 8, which was uploaded on April 12, Friday late night. The court added that the governor could not sit over bills and adopt the concept of absolute veto or pocket veto, as their constitutional powers were not supposed to be used arbitrarily. Justice Pardiwala in his judgment clarified that it was not undermining the office of the governor, Dr. Ravi, by giving a timeline for their work under Article 200, but it must due diligence should be given to the settled conventions of parliamentary democracy. The court also clarified that we are in no way undermining the office of the governor. All we say is that the governor must act with due diligence, deference to the settlement conventions of parliamentary democracy. Also, it said that respecting the wills of the people and the legislature, as well as the elected government responsible to the people and the state government, he must perform his role of a friend, philosopher and guide with dispassion, guided not only by consideration of political expediency, but also by the sanctity of the constitution oath he undertakes. The ruling Apex Court clarified that once the governor withholds assent, he is obligated to forthnow and procedure outlined under the first proviso, which mandates action as soon as possible. The court has also said that the governor cannot sit on bills and exercise a pocket veto on them. There must be a sense of expediency. There is no scope for the governor to simply withhold assent. Under Article 200 of the Indian Constitution, the bills passed by the state are supposed to clear the authority of an act, and without this assent, the bills are just documents of aspirations that do not come into effect. Justice Pardiwala further said in the judgment. It is a 450 lengthy judgment. The court also prescribed timelines regarding the issue of bills. So let us clarify these issues. The timeline is a maximum of 1 month for withholding assent and reserving the bills for the president with the aid and advice of the Council of Ministers of the State Government. Finally, in the case of a bill presented after reconsidered by the State Assembly, the governor must assent to the bills within 1 month. It is also been given a timeline of 1 month by the Supreme Court. The Supreme Court also emphasized that failure to adhere to these timelines will invite judicial scrutiny. If somebody is aggrieved, like the governor is aggrieved or the state government is aggrieved, anybody can approach the doors of the Supreme Court or the concerned court for their aggrieved complaint or aggrieved prayers to the court. So court will finally decide if the party is aggrieved by such kind of orders. The Supreme Court also said that the governor didn't have any discretionary powers, and giving governor the absolute discretion would turn him into a super constitutional figure. Justice Pardiwala, the lead judge of the bench, said that the governor is merely a titular head or a de jure head of the state of Tamilnadu, and the state is entrusted to the chief minister and the council of ministers, who can say to be the head of the state. The governor cannot be accepted as an all-pervading super constitutionality authority. Highlighting and clarifying that the governor has a role to play for a healthy functional democracy, the Supreme Court said before the governor assumes office, he undertook an oath to discharge his functions to the best of his ability in order to preserve, protect and defend the constitution of the country and the rule of law, along with avoiding to devote himself to the service and well-being of the people of the state. Coming down heavily on Tamil Nadu Governor Dr. Ravi, the Supreme Court has also clarified that reservation of 10 bills by him for consideration of the President was in contravention of constitutional provisions. The Constitutional Assembly debates indicates that the framers of our Constitution envisage the position of the governor as that of a guide, philosopher and a friend of the government and the people in general. The Constitutional Assembly, in its wisdom and in consonance with the position of the governor in the parliamentary form of government, removed the phrases in the discretion from the substantive part. The Supreme Court in its landmark judgment has said. So let us see how this judgment will have a bearing on state and other functions of the elected government. We have to wait and see. But meanwhile, another development has come that MHA, that Ministry of Home Affairs, is planning to file a review petition in the Supreme Court challenging the judgment of April 8. So let us wait how the review petition will file, and then we will report and we will again try to analyze what is the review petition says and all that. Thank you for watching the video. Thank you very much.